District 1.
Here.
Paul Chavez present. District 2.
Chuck McEwen present.
District 3.
Martha Brown, present.
District 4.
Here. Robert.
And District 5, I'm here. Okay, our first item is approval of the agenda. Do I have a motion?
So moved.
Hear a motion. Do I have a second?
Second.
Second. All those in favor signify by saying aye.
Aye.
All those opposed? Hearing none, the motion carries. Next up, we have the January 17th minutes. Has everyone had a chance to review those?
Yes.
Hearing some affirmative, do I have a motion to approve?
So moved.
Will you please identify yourself for the purposes of the recording?
Chuck McEwen. So.
Hearing a motion from Chuck, thank you. Do I have a second?
Paul Chavez, second.
Thank you, Paul. All those in favor of approving the January 17th minutes signify by saying aye. Aye.
Aye.
All those opposed? Hearing none, the minutes are approved. I believe we can move on to the main event here, which is the evidentiary hearing. Do we have the parties in attendance?
Sarah Berger on behalf of the complainant, Carl Peterson.
Thank you, Ms. Berger. Is the complainant in attendance as well?
Yes, he is.
Thank you, ma'am. Do we have anyone from respondents camp? Hearing none, it appears the respondent has chosen not to attend this morning, so we'll do the best we can without their presence. What witnesses do we have?
Mr. Chairman, this is Jacob Candelaria, attorney for respondent. I assumed your staff was going to tell you, but apparently they have not, that my client filed a notice of non-appearance. She was not timely served with notice of this hearing. Your rules require 10 days prior notice. She was not given 10 days prior notice. She will attend at a hearing when she is given timely notice. Furthermore, my office advised your staff that we have filed with the district court a writ of mandamus and application for declaratory judgment to enjoin this board from exercising jurisdiction over matters it does not have jurisdiction. So if the board continues with an evidentiary hearing today, it is at prejudice to my client's rights. The board did not provide timely notice. She will appear when she's given timely notice, but not until that time. I'm concerned that your staff didn't seem to have passed on that message that we provided timely. Thank you.
All right, Mr. Candelaria, I did receive a notice, so let's continue with the evidentiary hearing this morning. If you're not going to participate, you can go ahead and put yourself on mute. Do we have the subpoenaed witnesses?
Vice Chair, I'd like to make a statement based on what happened last night. And I'd like to make a motion as well.
Go ahead and make your statement.
Obviously, we got notice at beyond the 11th hour last night that Mr. Candelaria and his client were not showing up today. He's disrespecting the authority of the board, the hearing process. He picks and chooses which rules he wants enforced and which ones he will follow. He argues untimely, I might add, that the board is violating its rules by holding the meeting without adequate notice. But the notice requirement was for setting the initial hearing. There is no requirement for the continuance. It makes sense that there's a elongated notice for the initial hearing because that is when parties are given an opportunity to present witnesses, witness lists, exhibits, file motions, seek subpoenas. All of those things require advance notice. The continuance does not. This is all a stunt to run the clock out on the matter. If the solution is, which I see that you're not agreeing to it, to reschedule this, then the next argument that'll occur on the eve of the hearing is that you violated the 90-day rule to hold this evidentiary hearing. Complainant, the board, myself, compliance staff have spent considerable time, money, and effort to appear and present the case twice. At the first hearing, despite being served a subpoena to appear in person, at the 11th hour, respondent and her attorney decided to attend remotely so that she could not be adequately cross-examined or examined. Now, she says she's unwilling to appear at all. Respondent feels free to violate this board's order requiring her and her counsel's attendance, but then argues she is under no obligation to follow this other rule because, in her opinion, that violates the board's rules. So which rules is she going to follow? I want to remind the board that everyone, including respondent, was given adequate opportunity to state when they were available for the continuance. This was scheduled 7 days ago. There was a problem with the notice. It should have been raised 7 days ago. This is the doctrine of latches. You don't get to sleep on your rights and raise them the day before the hearing. Because of respondent's unresponsiveness and her failure to defend this matter, I move for a default judgment against respondent. And I would like to explain why there is a basis for a default judgment. I'm reading from some Gallegos v. Franklin. Default judgment is available when the adversary process has been halted because of an essentially unresponsive party. In that instance, the diligent party must be protected lest he be faced with interminable delay and continued uncertainty as to his rights. The default judgment remedy serves as such a protection. Furthermore, the possibility of a default is a deterrent to those parties who choose delay as a part of their litigative strategy. Also, Schneider v. Saker, New Mexico Supreme Court case from 1971. A judgment goes by default whenever between the commencement of the suit and its anticipated decision in court, either of the parties omits or refuses to pursue in the regular method the ordinary measures of prosecution or defense. A judgment by default does not involve the merits of the case. It is based solely upon the fact that whatever case the party had, he did not appear at the proper time to present it or defend it. I edited it. This board has
thank you.
authority, I'm sorry, one last. The
Go
board
ahead.
has authority to enter default judgment under New Mexico statutes 12.811, the Administrative Procedures Act. 12.811I says, where relief or procedure is not otherwise provided for, rules of practice and procedure applicable to civil actions in the district court may be utilized by the parties at any stage of any proceedings. I'm invoking Rule 1-055, entry of default judgment when a party fails to defend. And I respectfully ask the board to issue default judgment in this matter.
Thank you, Ms. Berger. The board will take that as an opening statement. The motion is going to be denied at this time. I think it's a very appropriate law that was quoted, and this board does have fairly wide latitude and discretion to apply civil district court rules. If we were in civil district court, that would most likely be the case. Seeing as we are in an administrative quasi-judicial proceeding, I think it's best that we get all the evidence that we can today, make a decision on that. I'd like to jump right into the witnesses that complainant has. See if we can minimize the impact on the time of those witnesses who did attend today. So, Ms. Berger, because you're essentially talking to an empty chair, you might have a little bit warmer bench than you might have otherwise. So I just want to caution you now that we want to make sure we're only admitting sound evidence. And with that, I'd like to ask, is Ms. Nix in attendance today?
Excuse me, Vice Chair. Again, just for
Yeah.
administrative purposes, Before we start the hearing, can you please have each person introduce themselves clearly for the record, the participants via the Teams?
Yes, can everyone in attendance please announce themselves? Can we start with in person?
Hi, Veronica Gonzalez Zamora, Board Attorney.
Chuck McCune, District 2 Representative.
Sorry. Robert Doucette, District 4.
Martha Brown, District 3.
Paul Chavez, District 1.
Good morning, John Grubisek, Bernalillo County Attorney's Office.
Kamala Ortiz Reed, Senior Paralegal for the Board of County Attorney's Office.
Oh, this one? Can I see your badge?
Rachel Florians for the Compliance Office.
Okay. No, the reason why is because you set up our alarms and you didn't stop. So we're trying to figure out who you were. Okay.
Sarah Berger, attorney for complainant.
Carl Peterson.
Carol Miller, Assistant to Sarah Berger.
Additionally, via the participants, the people who telephoned in or logged in, if they could please identify themselves. We have a phone number of 505-410. You could identify yourself. Okay, we are not able to hear the people if you are unmuting your mic. I am going to provide my email address. If you could please email me your name as a participant, I would appreciate it. Again, this is for the record. R is in Rachel, F is in Florence, L is in Love, O is in Oreo, R is in Rachel, Y is in Yo-Yo, A is in Apple, N is in Nancy, C is in Charlie, E is in Egg, at bernco, BERNCO.gov. If you could please email me your name, I would appreciate it. Thank you. Okay, my apologies, Vice Chair.
No problem. Okay, Ms. Berger, the motion having been denied, could you please preview the evidence that you intend to put on this morning, including your order of witnesses?
Mr. Vice Chairman,
Yes.
this is Martha Brown, District 3. I move that we enter a closed session.
Hearing a motion, do I have a second?
Second, Chuck McCune.
Second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed?
Let me revise that motion just to clarify. Pursuant to NMSA 1978, Section 1015-1, subsection F.
Okay, thank you for essentially renewing that motion. I believe we're going to go into closed session now. Let's see, I don't know if the host can put me in a lobby or how my part is going to go.
Kevin, do you want us to ring you on the phone?
Yes.
Would be maybe easier? Okay. Can you give me your telephone number?
Yes.
Veronica, I have that.
Oh, you have it?
I
Okay,
can
I'll get it
provide
from Rachel.
Okay.
We're leaving.
Okay.
Oh.
Oh,
Make it easy.
thank you.
Okay.
Sorry.
No, we have all these people that we don't know.
Right, I think we have to leave.
So we'll leave.
Thanks for giving me.
anymore, because they were gonna talk to him.
Good morning, this is Rachel with the Compliance Office. For all participants via the Teams meeting e-bite, if you could please mute your mic if you are not currently speaking, that would be appreciated, as we're just getting the background noise and the echo. Thank you. This is just a mic check for the court reporter.
Thank you. Switch to my old password. Oh, they fixed it. So, the new password first or last. It required, still printed, it was 20 characters. Yeah, you want to just do one, just do 10 passwords. Or one character, so you want to. Yeah, they have to be. So that's password. So just. I started changing. Yeah. You can get that in this control. Off the blue screen, once you get that, that's what. To control. Sorry.
We're ready, Kevin.
Okay, is everyone ready to re-enter the open meeting?
Are we back on the record? We are back on the record in Peterson versus Piscotti. Let the minutes reflect that the matters discussed in the closed meeting were limited only to those specified in the motion or notice for foreclosure, and no action was taken. This is Paul Chavez.
Thank you, sir. Before we broke, we had a renewed motion by complainant. I'm going to go ahead and deny that motion once again. Council, the motion is well taken. That's a reasonable position, but we'd like to get all of the factual basis on the record today. Can you go ahead and state your order of witnesses and what you're planning on presenting?
Yes, Vice Chair, I just, for the record, for my own preserving the record, I'd like to make an alternative motion that the facts pled in the complaint be accepted as true based on the fact that respondent is not here to deny them.
They will be taken into evidence and considered in deliberations. One other housekeeping note, do you have any witnesses for direct, or were you planning on crossing Ms. Nix? Would you like to treat her as adverse? What is your plan to proceed with laying on the evidence?
Was my motion denied? I'm sorry, I didn't hear that. I had a motion to have the facts pled in the complaint accepted as true. I'm prepared to offer additional evidence that came to light since the filing of the complaint, but I would like to make that motion that respondent is not here deliberately to defend those allegations. I think they should be accepted as true.
Again, they'll be accepted into evidence as part of the evidentiary record, and the record as a whole has to support the assertion. It's not necessary to rehash those facts that were alleged, but
moving forward, my plan, I would like to say how the fact that respondent is not here, and that I'm presenting a case where she is a key witness, is severely prejudicial to my client. Postponing is not an option. That is also severely prejudicial to my client. So I have to preserve these objections in case of appeal, but I do want to have noted for the record that I strongly object to the board not granting default judgment or not just accepting the facts as true. And having to prove a case where key witnesses are not here. I will also mention that Ms. Allereid, we attempted 3 or 4 times to serve her. The process server texted her. She put him off until this week to meet with him. I asked her attorney to accept service. I have an email from him where he said he would not. Again, another key witness. Ms. Nix is at the Roundhouse. She stated that she would try between committee hearings to testify. The fact that I could not subpoena her as well, the process server tried twice. The fact that she's voluntarily trying to appear, I'm going to take that and, try to work with that, but I don't know when she might be available. So this case is difficult to prove under these circumstances, and I just want to state that for the record, and I ask the board to give a little leeway on some of my requests and how I need to schedule witnesses, present witnesses, offer exhibits, especially since, sorry, Vice Chair, that you're attending remotely. But with that said, I plan to call the complainant. I plan to play Commissioner Piscotty's statement from the preliminary hearing as evidence, as a witness who's unavailable. I plan to call Ms. Nix. I don't know if she is going to be a hostile witness or not. And I have a rebuttal witness, an employee from the county, Mr. Enrico Grotti. He is going to testify as to whether or not Ms. Allereid seeks official action. And finally, I have a packet of certified public documents from the Secretary of State that I'd like to enter as evidence that show the campaign reports filed, when they were filed by then candidate Piscotty. I have a document that I would ask the board to take judicial notice. It's a publicly available document. It has the website to it. It wasn't a report, so the Secretary of State couldn't certify to it, but it is part of Ms. Piscotty's campaign filings. You can find it online. It shows that the Secretary of State issued a fine of $3,350 for her late filing. That was later waived. And I have campaign reports that were also certified by the Secretary of State, matched with lobbying reports of Ms. Allereid to show that she uses Allereid Consulting and her name, Vanessa Allereid, interchangeably. They're one and the same. It's a doing business as. And that is the extent of the evidence that I'll be presenting. I'll try to do it in a manner that's makes sense, but it's dependent on some of these witnesses. I told Mr. Grotti that he probably would be a rebuttal witness and not offered until this afternoon, so I'll have to make sure he's available, and I'll have to coordinate with Ms. Nix. But for now, I would ask the compliance office to play into evidence Ms. Piscotty's testimony from the preliminary hearing. It starts at 12 minutes and 58 seconds and runs till 19 minutes and 48.
Mr. Vice Chair, before we start hearing any testimony, just as in the last hearing, I would like to invoke the rules so that we can be sure there aren't any witnesses that will hear one another's testimony. To do that, I would like to know who's on the line.
Yes, that's a good point. Can we have everyone on the line identify themselves? That is going to be important for this portion.
Oh, Mr. Chairman, this is Jacob Candelaria. I am still here. I think at
Thank
this
you.
point, to amend my entry of appearance, I will waive a timeliness objection as to myself, and I will represent Commissioner Piscotty's interest here today. She, however, has not waived the timeliness objection we have stated. Thank you.
I absolutely object to that. You can't be changing the rules based on what he hears is now going to be the evidence.
Yeah, Mr. Candelaria, I would like to get some clarification on that last request of yours. What are you intending to do at this hearing today in light
Sure.
of what you've already stated?
Sure. Mr. Chairman, we filed a motion to quash the subpoena motion to get a protective order asserting in part an argument of timely notice, which we addressed this morning. At that time, I entered my appearance as a special appearance solely to advise the board that my client would not appear due to the fact she was not served with timely notice in violation of this board's rules. At this time, since the board has decided to proceed to a merits hearing, I am amending my entry of appearance for today simply for purposes of asserting objections on behalf of my client, to preserve them for what is inevitably going to be an appeal in this matter.
Do you intend to call any witnesses, or your client is not present? Have you consulted this position with her?
I have not consulted this position with her. I do believe it is the appropriate measure. I am not intending at this juncture to offer any evidence because my client maintains that she was not timely served. So I'm in a difficult position where in order to put on a case in defense for her, there needs to be timely service. There was not. So I'm here sitting in an unusual circumstance where the board is proceeding to hear the merits of the action. We would not object to rescheduling. We would not object to extension of the 90-day rule, which the chair has good cause to extend. So in light of the what in my experience in 6 years of practicing law is an extraordinary circumstance, what I am entering now or amending my entry of appearance is simply to preserve and assert objections for the record for my client.
Again,
Okay,
I object. This client is not here.
Ms.
I'm
Berger,
sorry.
we are very clear on your position. Thank you.
Okay, Mr. Candelaria, did you state that you advised your client not to attend?
I did advise my client not to attend because she was not timely served in violation of this board's rules. And we discussed all of the various options that could result from that.
Okay, Mr. Candelaria, I'll allow you to make objections on evidentiary matters only. I think the time for argument and evidence from respondent has passed when you forego that opportunity to have your client present. Again, I think it's noteworthy that as party to this proceeding, it's not required that she be subpoenaed. And so these notice requirements that you reference, really that doesn't apply, seeing as this is a continued evidentiary hearing of which you had actual notice that was scheduled with the parties. So I think we need to pay a little bit of respect to the witnesses that have been subpoenaed and the public who's coming out to this proceeding that we chose to make public via this course of action. So I think without further delay, Ms. Berger, can you please call your first witness?
Who else is on the call?
No, Your Honor. I strongly object. He instructed his witness not to appear. He does not get to appear just on his own, not representing a witness or a party. The party is not here. He stated he would not attend. If you are going to go forward I need a recess to meet with my client because this is frankly outrageous that you are allowing Mr. Candelaria to keep changing the rules at the last minute.
I have a question. I have a
Your
question.
concern is,
If there's anyone not following the rules, it is this board. Thank you.
I have a
okay.
question.
I'm gonna have to ask that you mute yourself unless you're addressed by the board. Ms. Berger, We'll grant your recess to discuss with your client. Mr. Candelaria, you can also discuss present status of the case with your client. If she would like to jump on the line and defend herself in this action, she still has an opportunity. The ruling I'm making is that counsel for respondent may object to evidentiary matters. That doesn't include arguments, all of these other. If there's a pending court case and there's an order from that court, this board will respect it. But until such time that happens, we will proceed. So, Ms. Berger, how long of a recess would you like?
Point of clarification, you are not allowing him to cross-examine witnesses as well, correct?
Correct.
If you could give me 10 minutes, I'd appreciate that.
Okay, that's granted.
Is there any way
Will you be-
if they don't respond?
Yeah, time of 10,
Say who they are.
I'm
jump
sorry.
back on.
We're back on the record to do it.
That's what I'm asking. Mr. Vice Chair, I'm asking if people do not identify themselves on the Zoom that we kick them off, because we've asked 3 times and people still have not some have not. We need to know who's attending this meeting.
Yeah, as soon as we come back from recess, I think we should start kicking people off if they've not identified themselves, because we are invoking the rule against witnesses being prejudiced by other testimony.
Vice Chair, if I may interject, I need a
Yes.
moment to contact our board liaison because we need to follow protocol of the county. And so I do not know if that is county protocol regarding commission meetings. So I will also check with her and then come back with an answer regarding that.
Yes.
Thank you.
No, but they
I
have
mean,
to identify them, because it can't,
If we don't know
you can't
if
have
they're
a witness
yeah.
that hears testimony. So if they don't identify themselves, I'm not, you can't just lay silent and go, oh, I wasn't supposed to hear that, now I can use that. Exactly. I don't see why it's difficult to say, I'm just with the public, I just want to hear this.
I unmuted myself. Do you want to know who I am?
Yes, please.
Hi. My name is Valerie Barkley. I'm a constituent of this district and a member of Indivisible Albuquerque.
Okay, so you're not a witness in this case.
I am sorry,
Thank
say
you.
that again, sir.
I said you are not a
No,
witness in
well-
this case.
No, I'm not.
Concerned citizen.
Yes, sir.
Thank you.
Sure.
Hello?
Yes, go ahead, sir.
Yeah, my name is Milan Simonich. I'm with the Santa Fe New Mexican. I'm covering this, and I object to you saying you'd kick people off of a public meeting. I don't see what the basis is for that. If you just tell the witnesses to sign off, instead of saying you're gonna eliminate people from a public session. Thank you.
Okay, that's not an objection, but I appreciate the input. Thank you.
Well, it's a public objection.
It needs to be a public meeting, but we just need to make sure. So.
Vice Chair,
Yes, ma'am.
after conferring with our board's commission manager, because it is considered an open meeting, we are not allowed to ask anybody to drop off of this call or the meeting. However, upon the board's request, if they could please identify themselves as a witness, drop off of the meeting during the testimony, and then I could log them back in, notify them via email to log back in when needed. They can email me at that same address, however you choose. But again, we are not allowed to ask anybody to leave this open meeting.
Okay, thank you for that clarification. So if I understand correctly, anyone who does not drop off will not be allowed to be called as a witness.
That's the board's determination. That would be for the board to decide. But as a representative of Bernalillo County, we cannot ask anybody to drop off.
Yes, understood.
Do you have any keys by chance?
Vice Chair, I'm ready to proceed. This is
Okay,
your-
thank you, Mr. Do we have everyone present in the room?
Again, there's going to be, the other witnesses are not present. The complainant is present. I'm going to ask to have for Ms. Piscotti to have the compliance office play her statement from the preliminary hearing as a prior statement of a witness unavailable. And it starts at 12 minutes and 58 seconds and runs till 19 minutes and 48 seconds.
Okay, I'll allow that. The complainant has already heard this, so go ahead and play when it's ready.
Mr. Chairman, I apologize. This is Mr. Candelaria. I'm, per your direction, conferring with my client. May I have 5 more minutes to complete that conference and then report back to you on the question you posed to me?
Yes, sir. Let's get that video queued up for complainant.
Thank you. I'll be right back.
It's ready, Vice Chair.
Thank you.
Mr. Chairman, thank you to the board and to yourself for that time to confer with my client. After conferring with my client, she, at this point, reasserts and rests on her objection that she did not have timely actual or written notice of this hearing. Board Rule 2E2 clearly requires that the board provide at least 10 calendar day notice to a party, quote, party of any hearing. That was not done in this case. For some reason, the board wants to ram this through when my client will waive any objection to the 90-day rule and allow a hearing to be conducted after that 90 days. As such, having conferred with my client, explained all her legal rights and risks, she again, in closing, reasserts that notice that she was not served with timely notice, thus she has no legal obligation to appear, and rests on the statement that she provided to this board at the preliminary hearing. Thank you, Mr. Chairman.
Mr. Candelaria, you stated respondent did not have actual notice. Did I hear that correctly?
That is correct. Timely actual notice, Mr. Chairman.
Those are two different things, Counselor.
No, Mr. Chairman, I believe that actual notice can either be timely or untimely, respectfully.
So you're saying she had actual untimely notice?
My client did not have any notice that the hearing of today would happen today until 7 days ago, Mr. Chairman.
Right, when she requested that it be delayed until 10. Okay, thank you for that, Mr. Candelaria. Ms. Berger, if you're ready, please play the tape. I would just remind you to excuse your client before you put on anything that he has not heard.
Point of correction, Vice Chair, parties are allowed to hear other testimony, only other witnesses. I'd like a clarification on that.
I'm sorry.
Parties are allowed to attend the entirety of the hearing. It is only other witnesses that are excluded.
Okay, but you do intend to call him as a witness?
Yes, but I'm just saying he has a right to be both a witness and to hear other witness testimony.
Okay, thank you. I'll allow that.
I want to, again, before going, allowing Mr. Candelaria to attend in any manner, even just objecting to admissibility of evidence, when your order dated 1/24/23 stated all counsel, all parties attend in person. He's not here in person. He said he wasn't going to attend. I still maintain my objection that he be allowed to participate in any manner unless
I agree with
the
that.
entire board votes to amend the rule or votes to enforce the rule. And I ask that the board consider that before we get going.
Thank you.
I make a motion that I agree with that. Paul Chow. I make a motion that we proceed, that we sustain Ms. Berger's objections.
Okay, hearing a motion, do I have a second?
I'll second. Robert Doucette.
Robert Doucette. Okay, the motion has been seconded. All those in favor signify by saying aye.
Aye.
Those opposed, nay. I'm sorry, I'm not present. Was the vote 2-1?
I think I was trying to abstain.
Well, the motion carries 2-1.
Mr. Chairman, so I also asked to leave this public meeting by virtue of that motion and order.
I would say you're excused.
Am I being ordered to leave this meeting?
No, sir, we're not taking anyone off the line.
I will stay and observe as a member of the public. Thank you.
This is Chuck McCune. I have a question for Mr. Candelaria.
Go ahead.
Mr. Candelaria, how is this delay consistent with your client's interests, if not for frustrating the opposing party? And what is the substantial purpose other than delay?
There are multiple substantial interests other than delay. And could I ask the commissioner to identify themselves?
Chuck McCune, District 2.
And there's multiple substantive reasons. Number one, your board has rules that were not followed, both with respect to notice, but that's not the only procedural action this board has taken to prejudice my client's interests. You allowed the complainant to amend the complaint at the last hour to add charges that were never subjected to a probable cause review at a preliminary hearing. So at this point, my client has availed her right to seek relief from the district court due to the fact that this board is asserting its jurisdiction over matters that it does not have jurisdiction to adjudicate to the prejudice of my client. And so the delay in this hearing, in addition to preserving my client's procedural rights that are clearly guaranteed to her by your rule, Section 2E2, and in addition to provide the district court time to rule on her request for relief, those are good faith reasons that are not in any way designed to frustrate opposing counsel or the opposing side. And I would respectfully subject, sir, or submit, Mr. Member and Mr. Chairman, that is squarely within my client's interest. Thank you for the question.
Thank you for your answer.
Mr. Vice Chair, I'm ready to proceed with the testimony of Charlene Piscotti from the prior hearing.
Go ahead, Counselor.
Sorry, do you know where you're certain?
My apologies, it's playing, but it's.
Oh.
Gotta sync the volume.
First of all, $5,000 that never came through my account. And as soon as I heard about that,
My apologies. The only way to play it is to have the echo.
I suggest I move to a different witness while we work that out. Ms. Nix is available at 11:45. I will call Mr. Peterson as a witness. Is he sworn or just?
Chair, this is Veronica Gonzalez Zamora. Will you swear in the witness?
Yeah. I Even have eyes on him. Is he here, sir? Please state your name for the record.
Carl Peterson.
Do you want to stand on this side, Mr. Peterson?
Sure.
You can see that, there you go, right in
Oh,
the middle
okay.
side, yeah. Perfect.
Okay, Carl Peterson.
Okay, thank you, Mr. Peterson. Do you swear or affirm that you will tell the truth to the best of your ability in this proceeding today?
Yes, I do.
Thank you. You may have a seat. Please go ahead and call the witness.
Good morning, Mr. Peterson. You've already stated your name for the record. Where do you live?
I live at 10700 Holly, Northeast, Albuquerque, New Mexico, 87122.
And are you currently employed?
I am semi-retired. I have a series of contracts that I pick up at various times.
What sort of profession do you do or did you do?
I'm an aeronautical engineer.
Okay. Besides being what you might have described as semi-retired, do you participate in any other volunteer activities?
Yes, I work with Indivisible Albuquerque, volunteer, and I'm also associated with the Democratic Party, and I do volunteer work for them also.
Moving on to your complaint in this matter, have you ever had any interactions with then Commissioner Charlene Piscotti?
I have. First off, I've seen her at various Democratic proceedings and rallies, and but the only time that I've ever actually seen her at work was when PNM decided that they were going to put into our neighborhood 1,500 kVA lines these lines were not installed. The planning commission had ruled that the line should run down Wyoming and they were going to run through our neighborhood, and we stood up and objected to it. The planning commission agreed with us, and then the PNM appealed the case and they went to the full council. And so Chairman Piscotti was the chair of that meeting. And that's the only actual official dealings I've ever had with her.
Did you file this complaint because you had any kind of grievance about how she ruled in that case?
No, not at all.
We just got to move. I don't have much time, so
No.
Sorry if I interrupt you. You supported her opponent in her primary race, correct?
Yes, I did.
Did you file the complaint because you had some sort of political?
No, I didn't.
Let me try to finish.
Oh.
Sorry. Did you file the complaint because you had a political grievance against Commissioner Piscotti?
No, I didn't.
When approximately did you file your complaint?
It was
What
filed
month?
a month in November.
And was she still a candidate at that time?
No, she had lost the primary.
Okay.
The voters had spoken.
Why did you file this complaint? Just briefly and generally, I don't have much time and I
filed the complaint because this is the process that a citizen has to go through if they find there's been an irregularity in the count.
What kind of irregularity?
We have a quorum. I'd like to introduce our new.
What kind of irregularity? How would you characterize the irregularity that you found in this case?
There seemed to be a donation to Commissioner Piscotti that was beyond the requirements of the Code of Conduct.
When you filed your complaint, you did not have any assistance of counsel, is that correct?
That's correct.
You engaged.
Counselor, please don't lead the witness. Thank you.
When did you engage me as an attorney approximately?
After the complaint was filed.
No further questions.
Okay, thank you, Counselor. Are you excusing the witness at this time?
excusing the witness, and I'm going to see if we can play back that testimony. If we're still waiting on that, I can move to introduce
First of all, the $5,000, it never came through my account. And as soon as I heard about that,
I'm sorry, I just want to clarify that I'm calling the testimony of Commissioner Piscotti during the preliminary hearing on December 2nd, 2022.
Yes, I can hear it. Thank you.
Yes, thanks.
that Ms. Ellery had sponsored a mailer postcard for me almost immediately. As soon as I got that notice, I posted it to my campaign finance report. And so I'm not in violation with the Secretary of State's office. And as I understand, that's not even relevant in this case because that Secretary of State is separate from the county code. But I just wanted to make that clear that as soon as I heard about that, I did post it, and that was on July 7th. And I heard about that through the person working on my campaign. I thought I was going to get a bill from her, but instead I got a message from her saying you need to post this on your campaign finance account. And contrary to the flattering remark of Carl Peterson that I'm a savvy or seasoned politician, that is not true. I'm a mental health therapist, but I did consult with somebody who is familiar with campaign finance law, who said that donation of the postcard, because it didn't go through me at all. Like I said, I was expecting to get a bill from my campaign worker, that should have just been counted as an independent expenditure and never gone through my campaign finance report. So I totally dispute that I had any wrongdoing in that. I did exactly what I was told to do at exactly like within the hour of receiving that message. I posted it. And so I do dispute that. As far as Ms. Ellery being a restricted donor and me having a conflict of interest, in cases where the topic of Santa Elena came up, you can check my record. I do not have a pattern of supporting Santa Elena. In fact, there was one case where I voted against it, and the landfill topic, which was then came up in the next meeting after that campaign contribution, and I did not attend that meeting. I recused myself from that meeting. So there was definitely no conflict of interest with Ms. Ellery after that, after I learned of that campaign donation of her sponsoring the postcard. So I did not even attend that meeting. I absolutely recused myself. And so there's that. And I guess, two other things. This complaint came to me the day before the vote for the appointment for that Senate seat. And so, first of all, Mo Maestas was an applicant, and he did everything right that an applicant should do. I always call applicants before the meeting and talk with them. He never did anything for me ever. He never gave me one thin dime or in any way did anything for me personally, or as far as I know, even for my district. His district is way on the other side of the county from my district. So there was never anything from him, and he was the applicant. So to say, it seems really convoluted to say that his wife, who's a lobbyist for Wall, had something to do with lobbying for his appointment, which, by the way, is still at this point, it's an unpaid position. It's not like he is making any money off of that position. And if anybody wants to ask me why I voted for him and not the other popular candidate, I'm more than happy to talk to them and tell them why. I stick by my decision. But I think the overall conclusion I want to make, because in the paperwork, the relief requested would be for me to recuse myself from the discussion and debate about that appointment. Like I said, this complaint came to me the day before that vote. And I think that for me to have recused myself would have just set a bad precedent that anyone can make an accusation. And I don't even know the right word to use here, but ask, demand, threaten an elected official to not do their job without even a preliminary hearing. That's just wrong. And so I felt like I had to just do my job and go to that meeting and put in my vote, and I guess let the process play out, because it just seemed like the timing of this complaint was very odd. So I don't know how these preliminary hearings go. Are there any other things I need to address here?
Commissioner, this is Robert Toussaint. No, as I read before we started, what we're looking for here, after you're done, we as the board will discuss what we want to do. We have two different avenues. So is there anything you want to add?
I guess, I just want to add, I'm doing my best, definitely after that heartbreaking loss of my primary. Maybe I just wasn't on top of things. Maybe I should have questioned that donation. And, like I said, it seems like it should not even have gone through my account as an independent expenditure. But, there was just, I got into this job as a therapist who just wanted to serve her community in a bigger way. And so I just I'm not a political insider. I'm not making any money off of this or getting any personal gain. I just want.
Members of the board, Vice Chair, in response to her statement that she had not violated anything at the Secretary of State's office, I would like to enter, or as an exhibit, a copy of a publicly available document, publicly available official document from her campaign report. It has the URL of where it can be found by searching the Secretary of State's campaign finance system, showing a fine issued on 7/8/2022 of $30,350 for a late filing fine for her 20-hour report of contributions, which should have been filed according to this document on June 3rd, 2022. It later shows on September of last year that the fine was waived. But I move to enter this into evidence.
Okay, Counselor, would you like to have your witness lay a foundation, or in the alternative, are you asking the board to take judicial notice of it?
I would ask you to take judicial notice of it.
Okay, go ahead and submit it, and we can do so or not as the board decides, but thank you for submitting that today.
As I said before, we sought the Secretary of State to certify it, but they cannot certify just some pieces of an actual report. They were able to certify the 24-hour report that was filed late. They couldn't just certify the screen that shows the fine. They did issue a response to a public records request that shows the fine, and I'm happy to provide that as well. But again, there was not sufficient time for that to be certified. But I do believe it meets the requirements for judicial notice, as it can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned.
Counselor, is that available for the board to find independently? Would we have to make a records request? How would we?
The document I gave to council has the URL. Yeah, you could just type in that, or all campaign records at the Secretary of State are publicly available. You can just go into the CFIS system, search by candidate, see when they filed reports, see if there's been any fines. But that particular copy has the exact web address. So yes, you could find it independently.
Okay, thank you. We can take a look at that and take notice of what we see there. What other evidence do you have you'd like to present? You mentioned a rebuttal witness. Could you put them on for direct or?
Yes, I'm waiting. Ms. Nick said she'd be available in 10 minutes. And so I don't want to call the other witness in the meantime, but I am looking for other documentary evidence that I'd like to admit. I can start with a large packet, and later I can point the board to the relevant pages. But for now, I have a few copies.
What are you handing out, Counselor?
It is a packet from the Secretary of State's office certifying various records, campaign finance records and lobbying report records. And there is a declaration of custodian of records from Annalise Ellis, the paralegal at the Office of the New Mexico Secretary of State, verifying the accuracy, that they were kept in the course of regularly conducted business activity, were made as part of the regularly conducted business activity as a regular practice, and are true and correct copies of the official documents filed with our office. I understand you can't see this, but if you could rely on other members of the board or your attorney to verify that what I'm telling is true, that this is a public record that has been certified by the custodian of records from the Secretary of State. There are.
Counselor, are you asserting that what you're presenting is not hearsay for the reasons you just stated?
It is not hearsay. These are just records of a lobbyist report. They are what they are. They just state that, well, I can point out when I get to the relevancy of certain documents, but I am just right now authenticating them. And I will talk about how they're relevant when I have time to do so. But I just want to rule in that these are authentic, and I'd like to reserve my time to go through them as part of my argument.
Okay, thank you. The board will accept those.
I'm going to try to contact Ms. Nix and see if she can log in.
Yes, please do.
Ms. Nix, are you on?
Yes.
Hello, Ms. Smith. Can you please state your name for the record? We are in a public meeting here in Leo County this morning.
Yep. My name is Taryn Nix.
Thank you.
Vice Chair, this is Veronica Gonzalez Zamora. Would you like to swear the witness in?
Yes, thank you. Ms. Nix, do you swear or affirm to tell the truth to the best of your ability today?
Yes.
Thank you. Counselor, would you like to proceed?
Yes, thank you. Good morning, Ms. Nix. I'm Sarah Berger. I am the attorney for Carl Peterson, the complainant in this matter. You and I, other than seeing you at the hearing last time, have never met. Is that correct?
Correct.
In 2002, did you work with Commissioner Piscotty's reelection campaign?
Yes.
What was your role?
I think the best description would be campaign manager, but I was really the lone campaign person, so her campaign team.
And when did you begin working on the campaign?
Not till May. I came in very late.
As her campaign manager, you were aware of Ms. Alarid supporting candidate Piscotty by sponsoring a mailer for her, is that correct?
I was the one that talked to Miss Alreed in May about the potential of using a credit that was at the print shop. I didn't know if I'd be able to utilize the credit. And towards the end of the campaign, I thought there was an opportunity to. So I put a mailer into a print shop using the credit from Miss Alreed.
Okay.
Plus campaign money. We paid too.
Okay. Let me back up. So you said you had a conversation with Ms. Alarid. Can you briefly and generally, to the best of your recollection, describe who reached out to who, what was said?
I don't remember who reached out to whom. I have a professional relationship with Miss Alreed at the state level. We were chatting about my races this past election cycle. Charlene's came up, Miss Piscotty's came up. During that conversation, she said that she had a credit at one of the local print shops in town, and did I need it? And I said, at that stage, I could not utilize it. There was not enough money in anyone's coffers to be able to do a mailer. And so I passed at the time. And then a couple of weeks later, I had found enough money to be able to utilize that credit for Miss Piscotty's campaign.
And did that require you getting permission from Ms. Alarid? Did she have to contact the print shop?
Yeah, she informed the print shop.
When did you, or did you learn that you had to report this credit as an in-kind contribution to Ms. Piscotty's campaign?
When did I learn?
Did you learn? Were you aware that you needed to report that?
I informed Commissioner Piscotti that it needed to be reported on June 3rd when I asked her to also pay the bill for the mailer.
Okay. Why June 3rd?
Because that's when we were invoiced for the mailer. The mailer did not land until the day before and the day of Election Day. It was a very last minute mailer. But we didn't, no money was exchanged. Nothing was done on our end until June 3rd. It was not, the company that did the mailer did not provide any invoice until June 3rd. So
When did the print shop create the mailer?
you'd have to ask the print shop the dates that they created the mailer.
Prior to June 3rd, though.
I don't know. I just know that they invoiced us that day and I asked Charlene to go by and make payment on the part that we owed for the mailer.
And then am I correct in your testimony that you also told her she needed to report the in-kind contribution from Ms. Alareed?
It was part of the invoice, yes, it had the credit, the $5,000 credit on the invoice.
Okay. Whose name was the credit listed as?
But there wasn't, it just had the credit on the invoice.
Didn't say Vanessa Alareed.
No, ma'am.
What was the name of the print shop?
Greetings.
If you recall.
I don't want to get, there's two of them with similar names. I believe it's Greetings, etc. Inc. It's on the mailer. That's what we also put out.
After you had discussions with Ms. Alareed about using her credit at the print shop, did you ever have communications after that regarding this in-kind contribution?
No.
Did she ever send you a letter saying this is the value of my in-kind contribution?
No.
Who created the mailer? Who designed it?
I did.
And one of candidate Piscotty's campaign finance reports show a payment on May 27th for $5,728 for communication services. Would that have been paid to you?
Is it to voter research?
Yes.
Yes.
Is that?
But that is for a mailer that I did in a different print shop. So there were 3 mailers. That was a different one.
Did Ms. Alareed provide any other kind of in-kind contribution regarding this mailer?
No.
It was solely the credit at this print shop.
Mm-hmm. Yes.
And if I understand your testimony, she didn't write you a letter saying, I provided an in-kind contribution.
No, ma'am.
You understood the value of the contribution from a bill that you received from the mail company.
Yes, ma'am.
And the mail company did not indicate the name of the person.
No, ma'am.
Okay. I have no further questions.
Thank you. Is the witness excused?
Witness is excused.
Thank you.
Thank you.
If I could have 5 minutes to try to get Mr. Grady here.
Yes, ma'am.
Thank you.
For the board, we're confirming that we are now off the record.
Is this a copy or one that you?
That's
Okay, thank you. So this is what she got from the.
Vanessa.
Oh, this one, yeah. I was just sending a copy of it, but-
He's on his way. He's in this building.
Okay, thank you.
Vice Chair, just so you know that the Commissioner Piscotty report has been emailed to you for reference. The board has a physical copy of it.
Okay, thank you.
Yes, that's me.
Sure, this is best to do this. The vice chair is running the hearing and he's going to swear you in.
Should I face the screen? or-
Yeah. Sure.
Where's the camera?
I think it's here, actually.
Okay.
Hello, I can see you there. Can you please state your name for the record?
My name is Enrico Grotti.
Okay, Enrico, do you swear or affirm that you will tell the truth to the best of your ability in all matters today?
I do.
All right, thank you. Counselor, please proceed.
Mr. Grotti, now could you turn? We're doing our best in this room. You've already stated your name for the record. My name is Sarah Berger and I am the attorney representing the complainant, Carl Peterson, in this matter. You and I have never met before, have we?
No, we have not.
Where are you employed?
I work for Bernalillo County, in the office of the county manager,
And what is your title?
deputy county manager for community services.
If you don't mind, can I refer to that as deputy county manager in purposes of the rest of my testimony?
That's fine.
How long have you, sorry, first, could you describe briefly and generally the duties of your current job?
Certainly. My duties include overseeing several county departments. They include the housing department, planning and development services, communications, parks, recreation, and open space, the ABC Community Schools Initiative, and the Office of Community Outreach and Engagement.
And how long have you held this position of deputy manager?
Approximately 3 years. 3 to 4 years.
As deputy county manager, have you ever had occasion to have conversations or communications with Vanessa Allery?
As deputy county manager, yeah, I've had some communication over the years, over the months, with Ms. Allery on various topics.
To the best of your recollection, how far back would you say those conversations go?
I'm going to be approximate here because I'm just going from memory. I would say maybe a year or two.
I can ask you a little bit more about those conversations, but for now, I will represent to you that I made a public records request of the county asking for documents related to meetings where Ms. Allery was present in in 2022. I'm going to show you a document that I received in response to my request, and first I'd like to mark this as, I think we are at Exhibit 1. Nothing else has been admitted. Exhibit 2. I'd like to mark this as Exhibit 2. And I'd like to approach the witness.
Yes, go ahead.
Do you recognize this document?
Yes.
What is the document?
This was a meeting that was scheduled August 3rd in order to have a conversation regarding an item that was scheduled for a upcoming hearing regarding a land-use matter, as I recall.
Do you recall receiving this document?
The meeting request?
Yes.
Yes, I did.
Okay. To the best of your knowledge, would you say this is a fair and accurate copy of the meeting request?
Yeah, I believe so.
Okay.
As far as I can tell today, guys.
Okay. Vice Chair, I move to admit Exhibit 2 as evidence.
The board accepts it at this time.
So regarding this meeting, did you state, I'm sorry, in your testimony, when the meeting was to occur or did occur?
I would have to
look at
go
the
to
docket.
memory. The meeting, this meeting, I believe, was August 3rd. As I recall, this was from time to time, all of us, the manager's office, are called upon by our commissioners to perhaps explain to them, help them understand, sit in on meetings on items that are perhaps that they don't understand completely, or they need additional detail or background.
Excuse me, witnessing. Will you please speak a little bit more loudly and clearly for the court reporter who's online?
I shall. So from time to time, we're asked to accompany our elected officials, our commissioners, and others to, if there's a meeting about something that is that the commissioner does not understand or wants a little more background, we often get called in to advise and to add detail or context to a particular request. In this case, I believe it was a land use hearing that was going to occur the next month, I believe.
Do you recall who was in attendance at that meeting?
Well, I was in attendance. I believe, yeah, Commissioner Piscotti was in attendance. A gentleman named Matt Look, I believe, was in attendance. And Ms. Howard was in attendance. And perhaps, I don't remember, Mr. Jim Stroger, who was also an agent for this particular application.
Who is Matt Look?
Mr. Look works for Western Albuquerque Land Holdings. He is one of their technical advisors. And he's been working with them for some time. Been working with those folks for a number of years on a number of different planning projects, all regarding West Side development and land holdings.
And is Santolina one of those projects?
Santolina is one of those projects, correct.
Okay. I don't see Matt Look on this meeting invitation. Do you know who invited him to the meeting?
That I don't know, and I do recall him being there.
And Ms. Allery was there.
That is correct.
What did you understand was Ms. Allery's role in that meeting?
My assumption is that Ms. Allery was there to facilitate the meeting, first of all, and create an opportunity for the applicants to give the commissioner an update, a briefing, an overview on what they are proposing in this particular action. Now, just a point of detail, these land use actions can be confusing because some of them are quasi judicial in nature, some of them are legislative. So in many cases, a lot of our elected officials want to ensure that they are not traversing any ground.
Did you understand Ms. Alareed's role to be that technical advisor?
I'm not certain. I think that certainly Mr. Look has had far more experience with these projects and is actually a technical professional. I think Ms. Alareed was probably there for the most part, maybe to provide some assistance, but overall more to facilitate, you know, the meeting.
You said you've had other contacts with Ms. Alareed over the past 2 years?
Yeah, I think from time to time, she's communicated with me that she would like to discuss potential projects that they're considering and so on. It's been overall more discussion of having a meeting than actually having a meeting.
What is your understanding of why Ms. Alareed was contacting you? For this meeting?
My assumption, and I don't know for sure, is that she's working with the Westland Development Group to advance, create opportunities so that they could articulate their proposals to the county, both the county staff perhaps, and brief some of the elected officials before it's proposed.
When you say proposing, some of these projects require approvals?
Correct, correct.
By whom?
By the Board of County Commissioners.
So this meeting was about a land use?
As I recall, this meeting was about a proposed level B master plan that was being proposed in the overall framework of the Santa Lena area. And the intent was to update Commissioner Piscotty on what exactly it entailed and what it was and what they plan to do with that particular area, some 600 acres or something like that.
And was there a vote after that meeting?
After the meeting, there was a vote. It was, I believe, a week or two later, perhaps, I don't know, it's in the record. But yes, there was a vote.
In prior meetings where there have been commissioners and Ms. Alareed present, or let me make that up, have you attended meetings where other commissioners and Ms. Alareed have been present?
Not that I recall.
Have you been contacted by Ms. Alareed to facilitate any of those meetings?
Not that I recall. I think this was one of the, well, first of all, we don't have a lot of hearings dealing with Santa Lena necessarily. So this one came about, I think, prior to this particular master plan request. It had been a couple of years since they had anything of this nature, this size in front of the board.
But she has, as you said, reached out to you before.
Yes, on this project and others, just, nothing of this magnitude.
And why do you believe she was reaching out to you?
I think that essentially she was working on behalf of the applicant to try to, facilitate communication between the staff, the elected official, in this case, Commissioner Piscotty, and the applicant, to communicate, their position, their desire for this particular land use request.
I'm going to try to put it in other words, to communicate their desire. Could you explain what you mean by that?
Certainly. So the Santa Lena development is a series of layered development, and the overall master plan creates a land use scenario where in order for entitlements to be implemented, successive plans need to be approved. So what was being proposed at that particular time is what's called a level B master plan, much smaller, much finer grain detail than the level A. Of course, the level A plan covers some 13,000 acres. These subsequent plans are designed and orchestrated to create smaller areas, yet master plan areas. And I think that in this case, the applicant wanted to communicate precisely what their intention was with this plan. I mean, there are staff reports, there's other material in the record in the public realm, but this is their opportunity to kind of present what they consider to be their primary goal in this particular master plan. That was primarily industrial type uses that were non-water consumptive. Okay, I'll keep on going.
And the commission ultimately voted on whether to approve
That is
their
correct.
plan.
The commission ultimately voted to approve the master plan.
Okay. And then in prior instances where she's contacted you, at least some of those instances has been on behalf of the Santa Lena project?
Oh, gosh. I think prior instances were to have conversations about the Santa Lena master plan project, but I think this is the first time that there was actually an orchestrated effort to get, to bring an elected official and the staff together and the technical staff to describe and discuss the project in detail.
Do you have any knowledge of Ms. Alarid having communications with the county regarding Tahajali?
That I don't know. I was not involved in that. If I was involved in that, it was very peripheral. So that I cannot answer.
Okay. Paseo del Volcan?
I think that I'm not certain about Paseo del Volcan. I think that there might have been discussions, mostly with our technical services staff, perhaps. That's another master plan area, or not, rather. It's close to a master plan area on the other side of the interstate. But I don't think that I've had direct discussions with her about Paseo del Volcan.
I want to make sure that I understand your testimony. You've had multiple contacts with her over the past 2 years, is that correct?
Multiple, yes. I mean, I'm going from memory, so yes, it's not unusual. I mean, it's not common, but she's reached out a number of times to try to discuss items that perhaps Western Albuquerque Land Holdings are considering doing.
And you sort of answered my question, but on some of those occasions, she was there on behalf of Western Albuquerque Land Holdings.
I'm assuming so, yes. I can't imagine what, those are the particular items she wished to discuss, so I'm assuming she was working with them.
She never stated she was there representing some other interest.
No.
And on some of those contacts, there was matters pending before the commission?
I think that just the instance with regard to the level B plan was the only one I can recall where there was actually a matter pending or that was scheduled to be before the commission. The other items were more ideas, right? What do you think of this? Is this possible? Does the zoning allow that? But this was the first item where I think there was actually an item that was scheduled to go before the Board of County Commissioners.
Okay. In your conversations or contacts with Ms. Alarid, did she ever explain to you what her role was with?
Not in detail. I mean, it was assumed on my part that she's representing Western Albuquerque Land Holdings. They have a number of folks that represent them in different realms. some technical public works types items, some zoning, some land use. So
All right, I think I can excuse the witness. Thank you for your time, Mr. Grant. Oh, I'm sorry.
A few questions for the witness. You talked about a level B master plan and level A. Are there other levels? And this is a compound question. What does the timeline for such a thing usually look like? And what did it look like this time? I imagine it's years long.
So yes, to your first question, the way that the framework is created, there's a level A plan, level B plans, and level C plans. The timeline can be years or decades, depending on what market forces are, what infrastructure availability is, and so on. In this particular case, I think the time between the first level B plan and this plan, it's about 6 years. So, it can be years between planning requests. It could be months. There's nothing stopping that, but in most cases, there's significant amounts of time that would elapse between these requests.
Okay, and in this instance, the level B plan, how much notice was there before that came in front of the board?
So this is the second level B plan. We call it the level B2 plan.
Okay.
In this planning framework, public notice is of critical importance. It is one of the bedrocks of the planning process. So we have to meet requirements of both zoning, open meetings, and other, there's public notice in the papers. We have to notify surrounding property owners. We have to advertise. I can supply those dates and those numbers and those requirements, but I would say that this was, this particular plan had been months probably in the public realm, allowing for people to comment. All of the planning documents that are involved in these hearings are also available to the public on our website. Whatever's available to elected officials is usually available to the public at time of posting.
Okay, sir, did I hear you correctly that you said there was notice of this for several months, but you would need to look at your records for a more accurate date?
I can give you a very accurate accounting of when things were posted. If I go into the, if you give me an opportunity to produce the paperwork. But to say this, procedural issues with land use matters are critical. So we take posting and legal notification very seriously.
Understood. Do we have other questions from the board?
Yes.
Go ahead.
Sir, how long have you been with the county?
This way.
This is Robert
Okay.
Doucette. How long have you been with the county?
Mr. Doucette, I've been with the county approximately 24 years.
So my question, sir, in your 24 years of experience working for the county, was this type of meeting out of the ordinary or commonplace?
That's a good question. I would say that this is a little out of the ordinary, just because this is kind of a special planning process. So I wouldn't have, how shall I say this? I'm having a difficult time pinning this down. Within the context of this request, it is not unusual for these types of meetings. However, the Santolina plan and so on in this process is a special process. So I would say it's somewhat out of the ordinary. Most of the time, we don't do a lot of work in this area. When we do work in this area, given the nature of this proposal, there are controversies, right? Or there are people that feel very passionate in both ways. It is not unusual for us to brief our elected officials on cases that are coming before them, especially if they have questions about, it's complicated, or they have questions about process, or what a particular zoning item means, or what the implications are. That's not unusual. In this context, this whole proposal is somewhat controversial, and so given that context, I have to say this was a little bit out of the ordinary.
And I just have one follow-up question. Did any other commissioners ask to meet with you about the level B planning before it went to the full board, or was it Commissioner Piscotti?
On this one, I don't recall. I know that Commissioner Piscotti specifically wanted someone to accompany her in this discussion to just make sure that, that the information being conveyed was consistent with, what the code was and what the plans were and so on.
Appreciate it, sir. Thank you.
Mr. Vice Chair, may I question the witness?
Yes, go ahead.
I wonder if you remember what the date is of the vote on the second Plan B when it came before the commission.
I don't remember off the top of my head. It was after the meeting.
Okay.
It was in September. I can provide you with that, but it's either the second or fourth Tuesday of September. Okay. I believe.
And would
it was a how shall I say this? I can just say this. It was on a normal scheduled agenda meeting. It wasn't a special hearing.
and when would that have been noticed, that agenda item in advance?
We would have noticed, well, several things. We have to notice surrounding property owners. We have to notice the journal. And then we notice on our website as well. So it would have been noticed at least at minimum 15 to 20 days before the hearing. And there's a number of different places the notice goes. As I mentioned, we follow the zoning ordinance with regards to our requirements for notice. We tend to over notice just to be safe in these matters. So,
Over notice in terms of people.
Let me give you an example. Yes, if the zoning code calls for folks within a certain radius of a particular property to be noticed, and it says 500 feet, we will always err on the side of making it 600 feet or 550 or whatever. It's a very important thing with land use to have appropriate notice in place.
Would you have knowledge of which commissioners participated in that meeting vote in September on this issue?
My understanding, as I recall, is that it was a full commission, and I do not recall Commissioner Piscotti being at that hearing or there for that particular item.
Was what was the nature of the discussion at this meeting? Was it about particular kinds of constituencies who might be upset about particular issues?
The public hearing?
No, this meeting.
This meeting.
Right.
Well, it was really, the nature of the meeting was essentially an opportunity for the applicant to make a pitch, make a kind of detailed explanation of what they're proposing for this particular 600 acres. One of the challenges we have with some of the Santolina properties, there's not a lot of water availability in these areas. So the property owner struggles to try to figure out what to do with some of these areas. So it was a discussion, as I recall, about, this could be an area for recycling, for different types of recycling, or solar panels, things of that nature. And that's what I remember being mostly discussed in this particular request.
You don't remember, for example, any of these sort of passionate issues that you mentioned?
Not in this particular meeting. I think this meeting was a little more technical, and I do think that this particular, and for that reason, perhaps, and I don't know why, I can't get into her head, but perhaps she wanted staff to be involved in the meeting, because sometimes these issues can get a little technical in nature with regards to the process, what the different zones mean, what is allowed, how is it phased in, those types of things, how it impacts the rest of the plan, roadway networks, open space networks, things of that nature.
Thank you.
Do we have any more questions from the board? Hearing none. Counselor, do you excuse the witness?
Just have one follow-up question. I want to understand as you were explaining things to the board. I don't have the ability of the court reporter to read something back that easily, but my understanding is you understood Vanessa Allery to be there on behalf of Western Albuquerque Land Holdings. Is that correct?
That's my assumption, yes.
Okay. And she has contacted you prior to this meeting, going back possibly 2 years. That's your
Year and a half or two, yeah. I mean, I don't have the information in front of me, but
your best
it
recollection.
wasn't common, but it wasn't, unusual.
Okay. And in those instances, she never stated that she was contacting you on behalf of anyone but Western Albuquerque Land Holdings.
Counselor, we're verging on hearsay with that question. You want to rephrase?
When she contacted you prior to this August meeting, who did you believe she was representing?
So she did not set up the August meeting, someone else did, right, but she was there. My assumption was always that she was, acting on behalf of Western Albuquerque Land Holdings. We deal with a number of folks that represent them in different areas, so that's my assumption.
Okay, all right, thank you for your testimony. I have no further questions.
Okay, thank you. The witness is excused.
Thank you.
Thank you.
Appreciate juggling your time.
Counselor, do you have more documents, more witnesses? Would you like to make closing arguments?
Well, I would like a little bit of a break before I have to make my closing argument to summarize the evidence that I have. But if we could, yes, I have one more document, no more witnesses. And again, I'd ask you to take judicial notice of this since the witness is unavailable. But again, this is a document from same place where you can find Ms. Piscoty's campaign finance reports on the very first page of the screenshot. And I've got again, the web address, the URL. It lists her top contributors. And I would like to admit this into evidence as Allery Consulting being her #1 contributor in her election campaign.
#1 contributor to respondent, Counselor?
Yes.
Okay, thank you. Is that marked Exhibit 3?
Exhibit 3, yes.
The board will go ahead and accept that at this time. Would you like a few moments before closing?
Yes, I would.
How is the board? Is everyone good on time? I'm sorry, Counselor.
What I'd like to do for your ease is point out, I gave a big packet of these documents. Not all of them are necessary and not all of the pages are necessary. So I would like to be able to go through and point out maybe in my closing argument, which evidence is material. And I would just like some time to consolidate what I heard from witnesses and put together my closing argument. So if I could have 20 minutes to do that. I don't know if people want a break, but
Okay, I'm inclined to grant that. I'd like some input from the rest of the board.
I would suggest maybe a 30-minute lunch break.
Okay, I would move for that.
I second.
All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay, it is 12:30 now. I guess we can reconvene at 1.
thank you, Vice Chair.
Thank you.
For the board, we are now off the record. Thank you.
Academic for you.
You look at the Mario County,
Okay, so this
it's
is,
like it might have been in September. But they had a bunch of land use, but I can't break it down. And all commissioners.
this is the one that I thought.
Right.
I worked for the county for 2 years.
Oh, it's the whole thing. You have to go to.
Land use, use,
Under fines, okay,
Yeah.
that's what I was just gonna ask.
I think they are just like the.
Okay.
To make these a bit easier, do you want us to just number these like one through?
They have like a budget board that.
You know, I wanted
It's a long
to, I'm not using all of them, so, but I wanted to show that.
The
Yeah.
pages that you want,
Yeah.
pretty easily, do you want me to just like number them?
Oh, that would be great.
And
Yeah.
then you want to number yours?
Yes.
I can do that. I'll start on page one. Okay. Thank you.
I'm gonna give you a job.
Oh, okay.
Where is another one of these packets? I need you to, let me just make sure where she's starting. Are you you're starting not with the declaration or the deck, you are starting at the deck.
Yeah.
Right there, number them all the way to.
So I think there's another stack, is it just one stack? That's,
I know,
Sorry?
is it just one stack that we can do this? We just have one copy?
All right, let me.
I think there's more. I don't know where it went. She's got one.
I have one for the
Okay, we're just gonna label them page number wise, like one all the way down, so that we can find the pages she's talking about, because they're all neat labels, like 1 of 4, 3 of, it'll be a mess.
I'm gonna
just
go grab my
label them
lunch.
also.
If we parked in that spot, we don't need any validation number here on
No,
this here,
behind
right?
the gate, the iron rod gate.
Mhm.
You're fine.
The chain link one, right?
A
It's right on the corner. It's right on the corner.
Mm-hmm.
B is.
Catty corner from here, right?
P is,
It says for patrons of Monroe County.
Mhm.
G is Gardy. Any other abbreviations you need, let me know.
Yeah, so mine will be a little bit long.
Oh, they still have that. G. Can you mute this mic now?
So,
Yeah.
Oh, that's right.
Probably lunch.
I'll let you know.
Do we have complainant and members of the board present?
Yes, the complainant is putting money in the meter, but I can start with that.
Vice Chair, Board Attorney is not in attendance at this moment.
Okay, let's wait just a couple of minutes.
Thank you.